Welcome, everyone. I see folks are just coming into the Zoom room now. It takes a moment for the Facebook live stream to start. So I'm going to pause for just a second here and we'll get started in just a minute.
Recording in progress.
Okay, I think we're set. So thank you, everyone, for joining us today. We're here to talk about our victory at the Wisconsin Supreme Court, the Kinnard Farms decision, and what it means for Wisconsin's clean water future. Yeah, it means a lot to us that you would take this time to come talk with us and hear what we have to say about this decision. And just the fact that you're willing to spend about 45 minutes to learn about a Supreme Court decision and what it means for clean water in Wisconsin probably means that you're the kind of person that in some way, large or small, contributed to this victory, whether directly or indirectly. Many individuals and groups contributed, and we thank you all. Before we go too much further, I want to introduce the panelists who are with us today. We've got Andrea Gelatt, Senior Staff Attorney at Midwest Environmental Advocates, who argued this case before the Wisconsin Supreme Court. Adam Voskuil, Staff Attorney at MEA and our expert all things agriculture. Evan Feinauer, Staff Attorney at Clean Wisconsin, which was a crucial partner along with MEA in achieving this victory. And Lynn Utesch of Kewaunee Cares and a longtime community leader and activist up in Kewaunee County. And Lynn's activism and leadership in that community runs through this success. So thank you so much for joining us, Lynn. Before we delve into the specifics of the case and have a discussion here, I want to provide a quick overview of some of the key legal concepts and themes in the Kinnard Farms decision. And then we will have a discussion with the panel. And then we'll leave some time at the end for questions. And you can use the question and answer feature at the bottom of your screen to submit your questions. If you're watching us on Facebook, you can leave a comment in the a question in the comment section, and we'll keep an eye out for it there. Okay, so let's talk about this case and what it is all about. So the Kinnard Farms case, on one level, is about the regulatory authority of administrative agencies like the Department of Natural Resources, the DNR. But on a more fundamental level, it is about one of the most basic human rights, our rights to clean and healthy water. And that connection between administrative agencies and clean water is because in Wisconsin, we rely on the DNR to ensure our access to clean water. The DNR is given authority to protect water in Wisconsin, and that authority comes from, in part, the Federal Clean Water Act. Under the Clean Water Act, the DNR has been entrusted with the administration and the enforcement of Wisconsin's water pollution permitting program. Under that program, the DNR issues permits to businesses and other facilities that discharge wastewater into the waters of the state. So that includes facilities like municipal wastewater treatment plants, industrial facilities, and concentrated animal feeding operations, which go by the acronym CAFOs, large industrial scale farms. At issue in this case is whether DNR had explicit authority to protect groundwater by including certain conditions in the permit for Kinnard Farms, one of the largest CAFOs in Kewaunee County. And the court was asked to rule on a 2011 law called Act 21 and rule whether that law, whether it and how it impacted DNR's authority to modify permits to include conditions that the agency deems is necessary to protect water quality, and specifically the meaning of explicit authority to include those conditions in permits under Act 21. So we'll talk more about Act 21 and the meaning of this phrase explicit authority throughout the discussion. But first, let's take a look at how this case began. So the Kinnard Farms case began in October of 2012 when Midwest Environmental Advocates and 5 neighbors of Kinnard Farms in the town of Lincoln in Kewaunee County, Linda, Sandra, Amy, Chad, and Roger, challenged a DNR-issued permit for Kinnard Farms that allowed that CAFO to undertake a massive expansion. Many of these neighbors had already experienced bacterial and nitrate contamination in their drinking water because of the sensitive geology in that region and because of the rapid expansion of CAFOs in Kewaunee County. As many of you joining us probably know, Kewaunee County, like much of Northeast Wisconsin, sits on fractured carbonate bedrock. That's a type of karst geology that's characterized by shallow soils over fractured bedrock, which allows contaminants at the surface to travel rapidly into drinking water aquifers. Therefore, Kewaunee County is really one of the worst places to concentrate enormous amounts of manure. And over the previous decade, that is previous to 2012, Kewaunee County residents had seen CAFO after CAFO expand, their water become more and more polluted, and DNR's response become more and more ineffectual. They and their families bore the cost of these trends, and Linda Koshart challenged the permit for Kinnard Farms, actually at the same time that she was fighting a MRSA infection. And Linda's life was threatened by this incident, and she nearly lost her hand. And in fact, that same year, her son also had MRSA and nearly lost his eye. Back then, Linda told us at MEA what motivated her to take a stand, and I want to quote her right now. She says, "I remember the time my granddaughter fell on the farm and cut her hands and knees. In an immediate reaction, she ran to the restroom to wash them off. I didn't want to frighten her, so I caught up to her and suggested that instead we rinse her cuts with a nice, clean bottle of water." Linda said, "A 6-year-old should not have to worry about safe water to wash her cuts, her hands, or her face." Linda says, "I had a very unsettling night worried about what I might have exposed my precious granddaughter to." With that as motivation, Linda and her co-petitioners asserted that the permit conditions in Kinnard Farms permit were not adequately protective. That is, that the permit did not contain conditions necessary to maintain water quality standards in and around their homes. As a result, they asked an administrative law judge, that's a DNR adjudicator, to amend the permit to include additional conditions, including a limit on the number of animal units allowed under the permit, basically a cap on expansion and a cap on the amount of manure that was going to be produced and concentrated around their home. Second, they asked that groundwater below the fields where manure is spread, where groundwater contamination was most certainly happening, be monitored by monitoring wells. And actually, in 2014, they won. That ALJ, that administrative law judge, found that Kewaunee County's drinking water crisis had been caused by a massive regulatory failure, and that the permit conditions that were being requested related to groundwater monitoring and an animal unit cap were reasonable, they were necessary, and they should be included in Kinnard Farms water pollution permit. That was a victory, but unfortunately, it didn't end there. That 2014 victory was just the beginning. After the 2014 decision, Kinnard Farms, along with its allies in special interest groups and the legislature, began an unrelenting series of procedural tactics, delays, and appeals to overturn this modest and common sense ruling. And we don't really have time to go into all the ins and outs, the twists and turns, but you see on your screen a slide that illustrates some of the main steps that occurred between 2014 and the present. Kinnard Farms asked then DNR Secretary Kathy Stepp to reverse the judge's decision. At first, Stepp declined to do so. There were some court proceedings. Over a year later, DNR Secretary Stepp tried to reverse her decision and reject the permit conditions. There were court proceedings that challenged that move. And this case actually had been on different procedural items up to the Supreme Court twice before the court heard oral argument this year in April, and before we achieved this victory in July. So let's talk about what the decision said, just in summary, and then we'll get into the details with our panelists. As you recall, one of the issues the court needed to rule on here was the meaning of the word explicit. And in its decision, the court determined that the word explicit is not synonymous with the word specific. DNR's authority, the court ruled, can be explicit and also broad. The court ruled that DNR has the power to impose a broad set of conditions when they are necessary to protect water quality. Even though there's no statute or rule that spells out verbatim the conditions requested by the neighbors of Kinnard Farms, the legislature has explicitly conferred broad authority on the agency to include those kinds of permit conditions when they are necessary to protect water. Finally, the court ruled that based on the facts and circumstances that were presented back in 2014 about that massive regulatory failure, the requested permit terms were necessary to protect water resources. The ALJ got it right. And I'll just note that now the actual implementation of those conditions, that is what size the animal unit cap should be and whether there should be groundwater monitoring under specific spreading fields, is to be determined by DNR in the coming months. So that's the summary. That sets the stage for this discussion, and there's no better place to start the discussion, Lynn, than with you. We've talked about this history, this winding road of the Kinnard Farms litigation. As a Kewaunee County resident and a longtime water activist, what would you say about how this case has affected your community?
First off, Tony, thank you for you and MEA. That without your help, we never would have got to this point. That, and I would like to say that we did miss one point, that way before we ever started with any of the litigation or anything, the retired executive director, Kim Wright, facilitated a meeting with the town residents here that was the catalyst for us to understand that citizens can actually fight for their rights with clean water. Without Kim coming to our community and showing the interest in caring, truly caring for our community, none of this would have taken place. So with that said, I think the one thing that, we were thrilled with this ruling. This was phenomenal. This was it's for the citizens here in Kewaunee County. It justifies all of our concerns, all of our issues that we've had. That while it's a phenomenal win for us, I think the other thing is that in the 7 years that we've had since this is the litigation has started, a lot of things have changed, and unfortunately not for the better. That because of the delays that have taken place, there have been multiple expansions of other facilities in our community. We've also ended up with re-permitting of basically all of our CAFOs so that they don't have to comply with the NR 151 requirements for an additional 5 years. So, unfortunately, the win is really good for us, but it also means that a lot of things have taken place in special interests, especially the Dairy Business Association and Wisconsin Manufacturing and Commerce. They have made it so that greater destruction has taken place here in Kewaunee County. We should have had herd caps, instead of expansions. We should have had in-ground monitoring instead of the same old practices that have taken place. Here just recently, we've had our first round of water testing since NR 151 went into effect. And basically we've found that nothing has changed with our groundwater. The groundwater testing basically has the same numbers as we had before the implementation. And I think unfortunately it was because of these delays and the re-permitting that was allowed, because this ruling took so long to come down and to actually have there be any enforcement for us. And I think that's really what was the biggest thing that we've had to deal with.
Thank you, Lynn. Thank you for painting that, what is, I think, a realistic and complicated picture of where things stand. And I definitely agree with your shout out to Kim Wright, and I hope that she's watching and knows how much we appreciate the foundational work that she did. You mentioned WMC, Wisconsin Manufacturers and Commerce. You mentioned Dairy Business Association. So Andrea, I'm going to actually throw it to you here. And if you could help us understand why Kinnard Farms, along with those large special interests in our state, would go to such lengths to oppose reasonable permit conditions on one particular CAFO in Kewaunee County.
Sure, thanks, Tony. One of the arguments advanced by Kinnard Farms and their supporters like TPA and WMC was that Act 21 withdrew the authority of DNR to issue permit conditions like the ALJ found were necessary to ensure compliance with water quality standards. So Act 21 was a law passed with relatively little public discussion. It made significant changes to the administrative rulemaking process, which is the process by which state agencies promulgate more detailed rules that guide the implementation of laws that they're charged with administering and enforcing. Act 21 also imposed a requirement that an agency must have explicit authority for every permit condition that it imposes. So the Kinnard Farms position boiled down to the argument that no statute or administrative rule explicitly says that DNR is allowed to create an animal unit cap or offsite groundwater monitoring as conditions of CAFO permits. And they argued that because the conditions were not listed verbatim in the statutes or the associated administrative rules, that DNR lacked authority to impose those conditions. And fortunately, the Supreme Court rejected those arguments.
What was it about those particular conditions, talking about an animal unit cap and offsite groundwater monitoring, that were significant, or were they significant as conditions, or was it more about the legal principle?
So these conditions themselves have rarely ever been included in permits previously. And offsite groundwater monitoring can bring better accountability that reflects the reality that the pollution from large farms like CAFOs can extend far beyond the production facilities. And an animal unit limit represents the potential to bring the industry, sort of back into balance with the surrounding landscape and geology. But it also provides a reasonable check for other key permit conditions, like the requirement to have 180 days of storage in a manure lagoon, so that the farm has the flexibility and is not forced to spread when conditions are unfavorable, like if it's raining or the ground is frozen.
Thanks, Andrea. Adam, want to bring you into the conversation here. What would it have meant for DNR's other regulatory programs had the court accepted Kinnard Farms' argument and the legal principles that the opposition was advancing?
Sure. Thanks, Tony. As DNR pointed out in its brief, Kinnard's reading of Act 21 would have made it exceedingly difficult for Wisconsin and the DNR to issue permits that complied with the Clean Water Act, the federal law related to water quality. Moreover, the court's decision here actually noted that it would have been effectively impossible to enforce the state's groundwater laws as they related to land spreading fields, given the lack of any other significant monitoring locations at those edges of fields. So I think, zooming out, an adverse decision could have significantly hampered the authority of DNR to carry out, other environmental objectives that previous legislatures had explicitly charged the agency to uphold. In other words, DNR would have been left without the ability to implement or enforce water protection laws that had been on the books for 40 or 50 years. As Andrea said just a bit ago, fortunately, the Supreme Court rejected those arguments, and affirmed that DNR does have the broad and explicit authority to uphold the Clean Water Act, the state's groundwater laws, and all of those other bedrock environmental protections, that DNR and the communities of the state rely on.
Yeah, well said. Thank you so much. Evan, we haven't heard from you yet. And DNR's authority to protect water was at issue in a companion case that you were deeply involved with related to high capacity wells. So I'd like to ask you if you could just talk to us a little bit about your involvement with that case and how it's connected to the Kinnard Farms decision, which you were also instrumental in the result there as well.
Sounds good. So first of all, just thanks for having me here to chat about these issues. Appreciate the opportunity. Yeah, so we had this other case that didn't start out as a companion case and ended up getting lumped in with the Kinnard Farms case. So the high capacity well case didn't start until 2016, which is a long time ago, but not quite as long ago as the Kinnard Farms case. But this case had to do with water quantity issues in the Central Sands region, and what DNR's responsibilities and duties were with regard to how they processed applications to construct high capacity wells for irrigation for farming in a relatively concentrated area, when we knew and DNR knew that the increased number of these wells, and again, in this pretty concentrated space, was having impacts on surface waters. So pump a bunch of groundwater out of the ground, it's not surprising you're gonna have impacts on streams and lakes. So this was a case that Clean Wisconsin, along with our partners, Pleasant Lake Management District, had filed in the fall of 2016. The reason that this case ended up turning into a companion case, even though in many ways it seems distinct, and this case had constitutional public trust doctrine issues that were pretty distinct from the Kinnard Farms cases, our opponents in the case, which started out as the Department of Natural Resources before the change in administration, and of course the applicants, the irrigated farmers who wanted this water, they made arguments that were in some ways very similar to those that our opponents in the Kinnard Farms made. In other words, they relied on this Act 21 law that you've already heard about. And they asserted that DNR did not have explicit statutory authority to condition or deny requests for new wells based on impacts to surface waters, the state constitution notwithstanding. So that was how they got connected. They ended up getting tied together through Act 21. And at some point, just kind of the timing of the appeals and how these things played out, we sort of looked at one another and realized that the fate of these cases very well may go together, because the court was going to be forced into a position of needing to at least try to have coherent rulings across the two cases. So they couldn't say Act 21 means one thing in one case and a different thing in another. And so we had to coordinate very, very closely to make sure that there was no adverse, negative side effects from arguments in one case spilling over into the other, because at the end of the day, we want to win these cases, but we also wanted an interpretation of Act 21 that didn't do damage to all these other regulatory programs, as we just discussed.
Thank you so much. And yeah, where you left off there is that the rulings in these cases may have had consequences far beyond these particular regulatory programs. And Andrea, I want to ask you this: what about even other state agencies that may or may not have anything to do with the environment? Were there any consequences to those agencies and other regulatory programs based on these decisions?
Sure. So when the Court of Appeals certified both of the cases to the Supreme Court, it recognized that the court's determination would have implications far beyond DNR's permitting processes or even the high cap well situation that Edwin just described. And in fact, the Court of Appeals said that the Supreme Court's decision would potentially touch every state agency within Wisconsin. And that's because many other state agencies operate under statutes and rules that provide them with authority that is both explicit and broad. And so, the legislature knows when it passes a statute that it will not be able to list verbatim everything an agency will need to do to meet the task and the goals that the legislature has assigned to that agency. And so therefore, the legislature passes laws touching a wide variety of subjects that affect people across Wisconsin that explicitly grant broad authority to agencies.
Yeah, and just staying in that vein for a minute here. And this might be a leading question, so you'll forgive me, but to what extent is what we saw in the Kinnard Farms litigation, the high cap well case, part of an ongoing strategy by special interests to undermine longstanding environmental protections that safeguard our environment, our natural resources, and public health?
So groups like WMC are continuing to pursue the dismantling of basic environmental protections through the courts. MEA is currently representing 5 clients as friends of the court in a consequential lawsuit brought by WMC that would remove the state's authority to order cleanup of PFAS contamination and could render the state's strong 40-year-old spills law inoperable with respect to many other toxic substances. So prior to the Supreme Court decision in the Kinnard case, one law professor said that litigants and their allies in the legislature were waging what he called a quiet revolution an unprecedented makeover in longstanding principles of state level administrative review. And then after the decision, the commentator said that the decision slowed down the revolution. So the cases are important victories in defense of critical legal foundations for environmental laws to even function properly. But there are definitely other cases and decisions on the horizon that touch on these principles. So the victory here is encouraging because it will serve as a building block for future efforts. And definitely key to those victories and to our ability to make these arguments is having people from directly impacted communities willing to stand with us and stand with us for years, like our petitioners in Kewaunee.
Thank you, Andrea. Evan, want to bring you back into the conversation. Andrea talked about just how folks on the ground in Kewaunee County were key to this effort. Also key to the effort was, as you touched on earlier, the collaboration between not only Clean Wisconsin and MEA, but other organizations, including amici, Friends of the Court, who got involved in the effort. Anything that you'd like to say about being part of that kind of broad-based collaboration on these cases?
Yeah, I mean, it really does take a lot of folks to do these cases. And by do these cases, it just touches on how there's so much more than just the actual litigation, getting the word out, building support for things, trying to raise money for things. It takes a lot of people doing a lot of different things, even just to do the litigation piece of it. And that, there are certain things that we can't do alone as organizations. And so being able to do both the Kinnard Farms case with a partner, and then I had another partner in the high capacity wells case, and then having so many nice amici in both cases, it really sends a strong signal, or we hope it sends a strong signal to the courts that were before about how much support there are for our positions, that we're not, out here doing something that's out of the mainstream or that doesn't have a groundswell of support behind it, which is why, we need a bunch of organizations. We need the people who support those organizations to work together on these issues. I think the amici in particular can be valuable because it can show how groups with slightly different focuses, whether that be environmental or public health or community autonomy or whatever the interests are, recreational. In the high capacity wells case, we had an awesome amicus brief from Trout Unlimited. These are anglers and fishermen. All these various folks all have similar goals of not allowing the DNR's ability to safeguard our environment to be undermined. So it's critical, and just from a personal level, being able to have partners in these cases that I trusted and that did good work made my life a whole lot easier and less stressful. So there's a personal component to this too that is going to give me strong and warm memories of these cases for a long time.
Thanks for sharing that. Lynn, we talked about the groups that have come together with respect to the litigation, but as we pointed out earlier, this all started in Kewaunee County. It started at a DNR hearing where many residents testified and explained their personal connections to this issue. So I'd like to ask you to take us back to that period in time and tell us a little bit what went into the organizing effort and the community outpouring back in 2012 to 2014.
Well, it took a lot of phone calls, a lot of sitting at kitchen tables, a lot of explaining, what the importance of this case really was to our community and to the state of Wisconsin. That we needed to have the community and the people that were being adversely affected by the very situation that was taking place to step forward and tell their stories. And that's the one thing that at the administrative hearing that Judge Bolt seemed to have the most understanding of is when the people's stories came out, it had so much pull and so much honesty to them that they're really the petitioners, I believe, won because their story was, well, one, it was the truth. It wasn't a story, it was their truth. It was their honest day-to-day living that they were willing to come out and bring to the court so that they understood what their lives were like. And I think that, no matter how those special interests try to say it's something different, when the people themselves come up and speak, you can't stop that from being heard. And I think that's really what it takes is, it takes a community. That's, my wife and I, we've always said that, we may have lost our water, but we gained our community. And that's really what has taken place. It's through a lot of years, and a lot of hard work by a lot of people that were willing to do this work, not being paid, no real benefit for themselves, that they were willing to stand up and to take a stand against what was really wrong, and that, taking care of that groundwater and their surface water and protecting the environment for not only us that live here today, but for our children and grandchildren.
Thank you, Lynn. That is well said. And we completely agree that those 5 Kewaunee County petitioners, you and your community, in initiating this case, it turns out that you are not only defending your families and your community, but also have ended up defending and protecting all of our rights to clean water in Wisconsin. And we are just so grateful for everything that you've done to contribute to that victory. So Adam, my last question is, what's next? What's on the horizon? How can DNR use the authority that was affirmed in this decision to protect water in Wisconsin?
Sure. Thanks, Tony. I kind of mentally subdivide what they can do to use this kind of affirmed authority in a couple different lights or timelines. To start, we know that DNR has already begun evaluating the need for these conditions in a number of CAFO permits across the state, considering whether or not an animal unit cap or groundwater monitoring is a necessary term for those permits. Additionally, looking a bit forward, we'll hopefully see DNR start incorporating, an analysis into the necessity of those terms in upcoming or currently pending permits. Those permits that, a CAFO applicant may have submitted documentation, but the process hasn't reached a point of public notice or comment, or DNR, reviewing that notice and comment and drafting ultimately a notice of final determination. Kind of in the aggregate, we're expecting to see a final determination from DNR that includes these permits over the next few months. Really digging in and seeing how they define that authority and how they review it and look at the underlying facts to support that decision, I think will be really valuable. Building off that a bit, maybe a bit longer term, we're hoping to see these and other meaningful permit conditions included in CAFO permits throughout the state. Certainly the facts on the ground in Kewaunee supported the AU cap and the groundwater monitoring here, but there are regions all around Wisconsin that are struggling with groundwater or surface water contamination. And some of their specific issues might be different, but they're really tied together by those contamination problems. And in the long term, we're hoping, or DNR really should use the authority affirmed by the court in this case to continue considering to include those permit terms and maybe additional other permit terms that tie into those necessary to ensure compliance with groundwater standards or effluent limitations. And those terms should, respond to the crises occurring in all of the communities around Wisconsin. More generally, I think DNR should not use or hesitate to use the broad explicit authority to protect water resources. Environmental laws were enacted to protect or by the people through the legislature to restore the waters of Wisconsin and protect the residents of the state. And by and large, the legislature gave DNR the regulatory authority to meet those ambitious goals. Industry opposition definitely isn't going to go away. Andrea already talked about that a bit. But the court's decision shows that the highest court in the state recognizes the purpose of, and will side with faithful execution of water protection laws.
Thank you so much. Thank you for answering that question, and all of you really for responding to my questions, before we kind of end this portion, I want to give everyone a chance to give a final takeaway or a reflection before we start with questions. So whoever wants to go first, Andrea, I don't know, maybe you could get us started.
Sure, Tony. You know, while this victory is important and exciting for all the reasons that we've mentioned, we definitely still need a multi-pronged approach to be effective. A single case itself will not broadly change things on the ground for Kewaunee or protect water. Instead, there needs to be large-scale changes to the way land is managed and manure is spread to avoid sensitive areas. And this victory also supports the idea that DNR should be assertive in using its authority in many ways. As mentioned, the 2018 NR 151 updates are a step in the right direction, although delayed, and we haven't yet seen their potential promise, but we still need to understand if those changes will be effective. Implementation of the proposed Northeast Lakeshore TMDL along the shores of Lake Michigan is another way that water quality can be improved and is an ongoing effort. In addition, you know, spending that may be part of the federal infrastructure bill can also be part of cleaning up our waters. And so we all need to keep working to advocate at each level of government for more resources for clean water.
Thanks very much. Adam, would you like to go next?
I would love to. Thanks. I'm gonna maybe give a couple different takeaways, and I'm hoping my second one doesn't, or my one of them doesn't steal Lynn's thunder too much. But I think one of the biggest takeaways for me is the benefits of on the ground work by communities. I think a number of people that I talk to daily or weekly hear me, you know, bring this up pretty often, but you know, there's exceptional value to kind of getting that background data and documenting changes to the environment. That work can really lay the foundation to give DNR the space to include these more robust terms or more restrictive terms. I know Lynn mentioned a bit, you know, the stories that individuals told, and certainly that's a huge part of it. But additionally, kind of the levels of groundwater or bacteria contamination or nitrate levels or surface water degradation plays a huge part as well. That work also, you know, can bring people together. It can inform neighbors and community members who may not always be as tuned in. You know, we get a couple, you know, really smart, really motivated people, and that kind of can galvanize an entire community and get people quickly up to speed once a permitting process starts. You know, and then jumping to my second point, because I'm taking two final thoughts. I think that one thing to note is that Kinnard is just one of the many examples of special interests claiming that a government doesn't have the authority to protect the environment or neighboring communities. We see these claims thrown around in a whole bunch of contexts, particularly at the local level. And so one of the other kind of takeaway points that I always have is, or that I come to think about, is that this decision kind of shows that these claims and the accompanying threats of litigation or you know, aren't always true, and that those local communities really shouldn't back down and should be, again, galvanized to kind of keep up this work.
Well said. Thank you, Adam. Evan, anything that you'd like to add to the conversation? And we'll end with Lynn.
Yeah, I guess the only thought I'll have that hasn't already been sort of echoed by my colleagues here is that, you know, this discussion should show the important but somewhat cabined role of litigation in advancing environmental protection. You know, if you're here listening to this, it's because you were interested in the outcome of a court case, and we're probably pleased to see a court rule the way it did. And so functionally what we have here is a court telling a state agency how to do its job, because in the past there were officials who, even if being charitable, simply were wrong on the law. And another way of putting this is that we had to go through all this rigmarole and all these years of litigation, which can be extremely expensive and uncertain. You know, we easily could have lost these cases. The judge wakes up on the other side of the bed that day. So you shouldn't assume, you shouldn't think that litigation is a tool that's going to work all the time. But I think that this really shows how important a piece of the puzzle this is, and that the fact that we at Clean Wisconsin and MEA can credibly bring and win these cases really helps us put the pressure on all those other levers that Andrea and everyone else was talking about, whether it's at the Capitol or it's with local governments. This is something that we'll do if we have to, and it's a release valve for a failure of some of the other parts of our government. But we really hope to not have to use it so much going forward. We hope that we can find ways to do this without 9-year and 6-year respective court cases playing out. So that's the only thing I want to, I want to make sure that everybody listening understands that we're really thrilled when we win these cases, but in a perfect world, we probably wouldn't have to bring them in the first place.
Thank you, Evan. As I look at the list of attendees who are joining us, I think that's a really important message because I see many longtime clean water activists who have contributed not only to this effort, but the multi-pronged approach that you and Andrea are speaking about that is so crucial. So we are all in this together. Lynn, you've got the last word before questions.
Yeah, I would basically like to reiterate, what everybody has said as well. But I think, as a farmer myself, I think the one thing that we really have to do is we need to change how we are operating farms. We can operate farms from an environmental standpoint, a clean water standpoint, and a profitable standpoint. And we need other state agencies to get on board and start to convert our farming practices to make it so that can take place. Right now, with this ruling, it says that the state agencies have the ability to do those regulations. It's time to start to do it. It's time that we don't just talk about it. We don't just wait again for another court case. It's time that everybody gets on board and really starts working for the betterment of all the people in all of our communities. The other thing is that I think we need to start looking at let's take a look at the federal level. Here in the state of Wisconsin, we now have this Supreme Court case that says that, that the state needs to be regulating the water quality and regulating. Let's start taking a look at the federal level. We need our federal partners to be on board with this process, and we need to start putting pressure on them to do the same thing. And again, for the citizens, don't give up. We got to keep fighting. We got to make this better for everybody. It took a long time and we're all tired, but we can't give up. It's so important for our communities and our state and our future. We need to keep working and keep fighting and keep putting forth the effort so that we can make it better for everybody. Thank you.
Thank you, Lynn. And we're just at about 45 minutes here, and we've got a few questions in the chat and some really great questions from a knowledgeable audience here. So I think we'll get to these and then we'll conclude the evening. So, and maybe we won't be able to get to all of them. We'll do the best that we can. We'll take about 10 minutes here. So Lisa Dorr from Polk County has 2 questions. I'll ask them both, and then whoever wants to jump in, feel free. The first is the limit on animal units based on spreadable acres? So we've been talking about animal unit caps. Is that based on spreadable acres? And the second is, will the high capacity well case be applicable outside the central sands area? And does it apply to non-irrigation water? Who wants to jump in first?
I can take the second question. So the answer is yes, it does apply outside the central sands, and yes, it does apply outside of irrigation water. So the high capacity well program, the way that DNR's review of the wells applications works is they just look to see if there are impacts on different water resources. So it doesn't really matter what the water would be used for in that sense, or where they would be located, except that, irrigation wells are going to use a lot of water. And that's why these wells can be particularly hard on streams and lakes. But there's no reason in theory that other uses could cause issues as well, whether that be for large dairy farms or CAFOs or for really any other kind of use or industrial use or anything like that. So yes, it has statewide impact.
Thanks, Evan. And Andrea, spreadable acres, is that what the AU cap will be?
Well, I think it a little bit has yet to be seen. I think that could be a factor that the DNR considers in determining an animal unit limit. But you know, if the DNR does issue a permit with an animal unit limit, you know, that'll be somewhat novel, and so we'll have to sort of evaluate. I think, you know, in the Kinnard administrative law decision, the judge also pointed to the need for additional checks on the 180 days of storage in the manure lagoon. And so there are other sort of factors that may come into play, including, you know, the presence of contaminated water. So I think, you know, yet to be seen, but that may well be one of the factors.
Thanks very much. Another question is, what are the consequences for Kinnard Farms from here forward if the well monitoring shows ongoing pollution associated with the farm?
I'll jump in here, but Evan and Adam, feel free to contribute. I mean, I think, you know, again, if it shows that the farm is in some way violating its permit, you know, I think then the DNR can take enforcement action against the farm. I mean, certainly the farm is not supposed to be contributing to fecal contamination of wells or other conditions in the permit. And I think if the monitoring does show those things, the DNR may take compliance action. So that may be one response.
Thank you. Yeah, I think that we could, I think that's sufficient for the limited amount of time we have. So thanks for fielding that, Andrea. Just 3 more questions here. One is, how might this decision affect the challenge to the spills law and the PFAS lawsuit, WMC's toxic chemical lawsuit that we referred to earlier? And maybe I'll start, and then if any of the staff attorneys want to jump in, they'd be welcome to. But in summary, these 2 legal issues are closely related, but they are distinct. And in our briefing before the Waukesha Circuit Court, as on behalf of our 5 clients in that case to uphold and defend the spills law, we cite these cases as supporting the principle that DNR does have broad authority under the statute that was passed back in 1978 to protect us all from toxic substances like PFAS. The Kinnard Farms case doesn't directly answer WMC's legal argument, but it is supportive for our side. And as we've been talking about throughout the evening, this victory is a decision that we can build on, and we are building upon it in the defense of the spills law. Okay, 2 more. Eric Godfrey asks, any special interest groups that were on our side or that saw the value in clean water? And he asked about organizations like tourism organizations. Were they amici that actually supported DNR's authority to protect clean water? I think the short answer is none of those business groups were directly related in that case. Lynn, I might put you on the spot here, and just, you know, since you're on the Door Peninsula and tourism is such an important industry in Kewaunee and in Door counties, what has been your experience with business groups around their interest in preserving clean water?
I think it's quite mixed. That unfortunately, you know, a lot of the tourism groups will acknowledge that our water quality issues are a detriment to their business. Unfortunately, they're very afraid to come out and actually speak up on these issues. You know, individual businesses see their, you know, the advantage of having clean water, but it's still, again, you know, there's a lot of fear out there I get from these business organizations that they don't want to be on the wrong side of you know, the Wisconsin Manufacturers and Commerce, or the you know, your Chamber of Commerce, those types of things. that they see the value, and actually they will donate their money. That's the one thing that maybe we don't see them stepping out and putting their name out there. But there are a lot of individual businesses that are willing to put their money out there to support the organizations that are doing the work. So it would be nice to get a few more business organizations to take and commit to that. And I think maybe in the future we will see it, especially as climate change has a lot more impact on things, and you have a lot more weather impacts affecting those businesses, and they look at the big picture. But I think right now it's very mixed.
Yeah, and from our perspective, I would definitely agree with that assessment as well. The last question we'll have time to get to right now is from Marianne Ewig. I'll read it. And then there are a couple of more questions, and we'll try to type responses to those after we end the video portion so that folks do get responses from us. But Marianne asks, are there any punitive damages as a result of this decision? Also, what is the current situation in Kewaunee for residents obtaining clean drinking water, and particularly for the family who had the courage to bring this suit and stay the course? So, Marianne, unfortunately, no, there are no punitive damages for Kinnard Farms. This type of permit challenge doesn't allow for punitive damages. We've heard from Lynn, and we know from our partners in Kewaunee County that of course, the drinking water contamination in that community is still acute. Still far too many wells are contaminated, and we have a lot of work left to do and to build from this decision. But I'm really glad that you asked about the family who had the courage to bring the suit. Andrea and Adam and I had the chance to meet with Linda and the Kosharts just a few weeks ago and visit them. And it's a mixed picture for them. And actually, I want to close the presentation here by reading the statement that Linda gave us the day the decision was released, because I think that's where we should end. She says, "This decision has been 7 years in the making. As we know, the wheels of justice move slowly. Opposing these efforts cost a lot of money that could have been spent on conservation practices dedicated to water quality. We all share these resources and need to protect them. It is a great day in Wisconsin when the future of so many of us outweighs the profits of so few." Thank you all for joining us. Those on the panel and everyone in the audience for contributing to this great victory. As Linda said, it was a great day when the future of so many outweighs the profits of so few. And as you've heard, we've got work to do, and we will do it and accomplish it together. Thank you so much.